Have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be used for this court, I would have attached them.
Fair enough.
I thought it was not necessary to attach them, but they are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG had the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say you also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit?
If you are required, we can't.
No, doctor, my question is,
they are not attached.
have you attached
Deliberately
the
not.
laboratory report of the alleged blood tests?
Deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. You can ask me, I can produce them.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Ri.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
Definitely not. They are not there.
Definitely not.
Yes.
In page 4, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you, there is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit first.
Trust me, I too have been laughing about it.
Sir, Your Honor, I must apologize. I must apologize. I must apologize, Your Honor, for that. I must apologize, Your Honor. But honestly, sir,
Yes.
if the question arises as to those documents that have been raised, if they are available, and if you are looking for justice and honesty, you can ask me to provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage, to even refer to them, because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage
Yes, Your Honor.
of his alleged illness.
Yes, Your Honor.
Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press?
Yes.
Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
It depends on the sensitivity of the
No,
issue.
the question, sir, is it standard medical practice for doctors
Yes, when it's
to
required.
call press conferences?
No, sir, we don't call for press conferences.
Okay.
Press comes to us.
When you are giving this press conference, the case before the Senate was proceeding, correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate.
Oh, no. In what capacity would I go to the Senate?
Good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he's been admitted in hospital?
I'm not sure if access to the Senate is available to every common person like me.
That's all from me. I will yield the floor to Mr. Mukele, my Lord, to wrap up the cross-exam.
My Lord, there is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gikonyo was hiding the first petitioner. That was posed, and I'm not sure that Dr. Gikonyo was given the opportunity to respond.
Why don't you respond in your response?
Just for the record, the witness answered, and he said his answer was to laugh.
Then we'll deal with it.
First, it's like to deal with it.
We'll deal with it, yes. Thank you.
My Lord, Your Lordship.
My Lord, Your Lordship, Senior Counsel Dr. Giancolo has covered quite a bit of ground. I will only have about 3 or 4 questions for this witness. I don't think I have much to add. Good morning, Dr. Giancolo. My name is Edwin Mukele. I represent the 3rd and 4th respondents. I've been permitted by Senior Counsel, Professor Ojienda, to ask 1 or 2 questions on behalf of the Senate and the Speaker. Now, I had your last comment to be that you are not sure, and this goes to Dr. Giancolo's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say, correct?
Yes, I said so, sir.
Now, Dr. Gikonyo, the affidavit that you've presented before court is sworn on the 28th of April, 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not the exact date, but I believe the same day that he came to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years
That is correct.
after he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, my lord. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I had you to answer to one of Dr. Kiakolo's questions.
Yes, that's why I'm here today.
The request has come now.
That's why I'm here today, sir.
So the request, Dr. Gikonyo, to file the affidavit and the attached documents has come now. That is what you say, yes?
Yes, I mean, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petitioner.
Yes.
Do you recall, do you know, when the petitioner first filed the petition? Might you know?
No, I don't. And I'm not interested.
You're giving evidence and you're not interested in the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, that I'm here purely on a medical issue, not on a court issue.
That is startling, Dr. Ari, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine, very brief. You have also confirmed that you do not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that?
Not at all.
You don't have any information on that?
And I agree with you, sometimes I really don't know why I'm here. Because my understanding is I'm here to answer medical questions about the petitioner in hospital.
So,
About law things and court and senate,
So-
I am ignorant.
so Dr. Gikonyo, Dr. Gikonyo,
Yes, Your Honor.
you cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceedings.
I wouldn't know. And
You
honestly,
really know.
Your
That's
Honor,
okay.
I have no interest in those matters.
That's okay. That's okay. We understand that you do not know why you're here. My Lord, those are my very brief questions on behalf of the Senate. I beg to. Thank you.
Dr. Gikonyo?
My Lord, we had Dr. Kamovas to ask just 2 questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamovo, and you have given directions before the commencement of these proceedings.
Let Dr. Kamoto speak for himself. Dr. Kamoto, did you file any affidavit?
Yes, my lords, my lady.
Did you file any affidavit?
We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you'll find, my lord, that not every one of us makes submissions or presentations on every occasion.
I think while you could be correct, if I allow you, then there's no basis why I not allow
We are most obliged.
My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I would refer you to paragraph 11 of your affidavit.
Yes, Your Honor.
On the reason why you filed the affidavit. Could you come clear or clarify why you swore this affidavit, referring to paragraph 11?
Your Honor, that is the way I understood it until I was made to understand that I had to understand other things of the Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I make this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question, underwent treatment. That was my understanding.
And you had earlier confirmed that the contents of your affidavit were true,
Completely.
to the best of your knowledge.
Completely.
Thank you.
And I took a note on that.
Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
If you want to know the exact time, it was 3:25. I have it.
What happened?
At around that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for history taking his weight, blood pressure, and such. At that time, if you allow me to explain, is the time we start now the admission process.
Thank you.
And admission is a process, not an instant. And as we are doing those things, there are accountants asking who is going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now admitted.
So when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admissions were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things, but he's technically not admitted because the accountants have not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, we put your full names and all your other names. There are clients we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
And Your Honor, I have said, our practice in a hospital to protect privacy, because these documents go around hospitals. The malaria parasite is positive, blah, blah, it's for the one, so we use codes.
Okay, but who is RG?
Who RG is?
RG
Who
is
is
the
RG?
Honorable Rigathi Gachagua.
Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile telephone number also.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary?
Not at all.
Thank you. And lastly, is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG?
It's a discharge summary.
It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely, Your Honor.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Kionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Why are you hiding him in your hospital? Please answer. It is a serious question.
I must say I laugh because I thought it was not a serious question, because maybe it is not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything, lab data that's available and available on demand by this court.
And apart from the documents, Dr. Gikonyo, you are here as a doctor, head doctor who was treating him.
Your Honor, that's why you called me, to answer those questions.
That's
and I've
right.
answered to the affirmative. I was the one who was treating him with my team. He was sick. We have data. We have provided an affidavit. If there's any further questions, we will provide it.
That's all, my lords, Your Lordship.
Thank you, Dr. for coming to clarify those issues. You may now take your seat.
My lords, can Dr. Gikonyo be released as a witness?
I will say
back
that
to
you
his
can
seat.
take your seat.
Okay.
You can be here or you can go home.
Oh, okay. That is the only clarification I will say. I don't think you'll be going home. You'll be going back to current surgery.
And there's something down there.
And there's water. There's water. There's water. Is that your water?
Yeah.
Yes, my lords and my lady. Again, we are now in the proper business of submissions, and I am ready to proceed subject to any other direction that you may want to.
What is the kind of directions that you will be seeking in relation to procedure?
My lord, if it works for the court, we would want to have the remaining part of the day for us as the respondents try and push and possibly conclude our submissions. We also hope that if time allows, we could then have any responses so that the matter is closed today. But I think what we would be asking for specifically is about, we will not go beyond 8 hours on the outer side.
We're talking about 8 hours and we're talking about concluding today.
Well, my lord, you know, you have previously set up about 10 p.m., but I wanted to get your direction so that we also know how to budget and plan as to when we'll be ending, so that we know which testimonies you take and whether or not you'd want to have us progress with the submissions this morning.
So, my Lord, we will, in the course of making our oral submissions, be also submitting on what has transpired during the cross-examination. So that need not bring any complication. The respondents will deal with the issues in the course of highlighting their written submissions.
So, my lady, on behalf of the National Assembly, we will have 4 of us making our submissions. We do not expect to go beyond 2 hours. That's for the National Assembly.
Yes, on behalf of Senate, I will lead the team and will be on point. We'll be assisted by
My Lord, on behalf of Professor Kidure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that our submissions were clear, and nothing we have heard since we made them has changed that position.
Your Lordship, if I may, on behalf of the 9th respondent, we require about 45 minutes.
My Lord, for the 10th respondent, we'll just do 1 hour.
My Lord, on the part of the commission, it will take about 20 minutes.
this commission.
The IBC, the 16th respondent.
My Lord, may I suggest that perhaps we start with the IBC, which is taking 20 minutes, and then we come to the parties who wish to take longer. And also wonder why my learned friend, Dr. Tiankolu, would require the same amount of time as the primary respondents. He is really an interested party.
I think those submissions were being made on the lines of the knowledge that I divided by half. My Lord, certainly will not give you 2 hours. I will not give you 2 hours. I will not give you 2.5 hours. That will give you sufficient time for you to make coherent submissions to this meeting.
Our only concern is parity of times. That side took about 10 hours. 10 hours. So we'll be taking less, even if you add all the times of the team. Even when you subtract the half, they still do 10 hours.
But we'll give you sufficient time. My Lord, yeah, for the record, for the Speaker, my Lord, minimum, my Lord will be taking not more than 30 minutes. That's 15, that's good. So can we have the person who set the pace 10 minutes at EBC?
If it may please you, my Lord, my name is Kibe Mungai. I appear with Mr. Kamwaro and Mr. Peter Koira for the 10th to 41st petitioners. We made our submissions on our petition last Thursday. My Lord, we are here for the simple reason that the following day, on Friday, the Constitutional Court of South Africa rendered a decision with regard to an issue of presidential impeachment that directly deals with part of the issues that was substantially raised on behalf of the first petitioner and by the 10th to 41st petitioners. A judgment that is directly relevant in this matter. Being proactive, Yesterday, the 12th of May, we filed supplementary submissions to bring, which we have served all the parties, to bring that issue to the attention of the court, and with a view that the supplementary submissions that we did, the court may certify them as duly filed so that they become part of the record of our submissions, and today, so that to enable the other side to respond, to be able to seek directions of the court on how we should progress based on that issue. We make this request for the simple reason that the Supreme Court, in the case of Sonko, that has been cited severally, indicated that the advocates and all the parties and the court have a responsibility to ensure that cases are decided on the basis of all relevant matters of law and fact and the best research that is possible. So we are under our duty, and we have done something direct, proactively, to certify that duty, that this is a decision that needs to be considered by this court. And the right procedure, if I may ask, is that I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe, in particular, the first petitioner, whom Mr. Ochiel said a lot of things about that issue of the Senate and the special committee, would have an interest in that particular matter. So may I request for directions on that issue? It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Muigai, had made submissions on behalf of the client Attorney General. So that's all, my Lord.
My Lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighty decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my Lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time to be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my Lord had suggested.
My Lord, that's a sensible suggestion on our side. And you also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
It's just that it is irresistible for the first petitioner not to join issues with Professor Gidu Muigai. But this decision is utterly irrelevant. I think he said, he told this court that the decision is utterly irrelevant. My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation. and on the jurisdiction of the court to question actions and decisions and resolutions of Parliament. This decision answers to those two issues, but if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with Senior Counsel, Professor Gidu Muigai. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
We have more or less agreed. We treat some Kibe's submissions on that issue. We allow particular submissions on that issue. And between now and then, and the time we retire, write a ruling, if you have an authority, just file it. Just file it and consider it.
Thank you. Thank you.
Most obliged. Only that we shall say something about it during the rejoinder. I would like to make that clear. Thank you.
My Lord, we have Ms. Joy and Mr. Nura, I think the present in court.
If Your Lordship could give me a second to catch my breath. It's a hassle to get from the back of the court to the front. If it pleases my lords, my lady, my name is Nura Abdul Kadir. I appear alongside Miss Joy, Miss Faith Kiende, Mr. Derek Asala, and I also hold brief for Mr. Mahat Somani for the 16th respondent, the IEBC. My Lord, together with these oral submissions that I will make, the 16th respondent also relies on the submissions it filed on the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my Lord, of October 2024. We will be relying on those documents, my Lords. We will briefly highlight on a single issue, my Lords and my lady, and that issue is the IBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My Lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of these submissions, the IEBC? My Lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my Lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my Lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft, at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Giz Muigai and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves the question that where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a deputy president. If you look at the qualifications of a deputy president under Article 148, the Constitution references you to the qualifications of a president in 137, which further references you to the qualifications of a member of Parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or clearance exercise as though the filling of the vacancy under Article 145 were an electoral process, which we humbly submit that it was not. my Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly, to satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lords, I humbly submit that this particular issue has been heavily argued before courts, and there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. That the IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. My Lord, the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one that we submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It would not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database-driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you've sought information from is a registered voter, and communication of the same to the requesting party. I mean, IBC would do that of anyone. If you were today to request that information from the IBC, it would provide it easily. It did not have to have come from the president for the IBC to have acted and given the information. So that information could have come either way. My lord and my lady, I will point out 3 decisions that speak to the same. That is, I believe it is in our bundle of authorities, County Government of Gachagua'S Gishu and 2 others versus the IBC, County Government of Kisii and 2 others versus the IBC, and County Government of Lamu and 2 others versus the IBC. Similar to this case, in all 3 cases, the position of deputy governor fell vacant for whatever reason. As is required by law, in all 3 cases, the governor nominated an appointee to take up the position of deputy governor. The individual was vetted by their respective county assemblies. And during this period of time, the IBC did not have commissioners, 3 of whom having resigned, and the rest, 3 of whom having retired, their term having come to an end, and the rest having resigned. The respective county governments wrote to the IBC requesting that it gazettes these individuals. The CEO then, acting out of abundance of caution, felt that this was a role reserved for the commission when it is properly constituted. And the courts, in specifically county government of Kisii and 2 others versus the IBC, said that this is a merely administrative task arising from an already concluded legal process and is not dependent on the composition or quorum of the commission. In county government of Gachagua'S Gishu and 2 others, the court said that it is an administrative function of communication and notification, and the Secretariat is capable of undertaking that role. The court, and I'm going to quote the court directly, does not call for a commission to sit, deliberate, and come up with a decision. Therefore, my lords and my lady, I humbly submit that if these simple tasks of communication, notifying, giving information were to be subjected to the commission, then the IBC would lack purpose in a period where the commission was not properly constituted and that there were no commissioners. Therefore, my lords and my ladies, we humbly submit that on those 2 grounds, two grounds that had been raised by the petitioners, that petition and those allegations fail as against the IBC. My lord, I'll take a minute just to make reference to the prayers that were sought against the IBC, specifically in the amended petition. That is prayer K. My lord, the prayer itself takes issue with the fact that the IBC provided the said information. My submissions have completely covered that the IBC plays no role. There is no constitutional role under Article 149. The only issue that arises, or that I haven't covered in the prayer, is the overnight clearance that violated Article 10 of the Constitution. And I have to say apologetically, my lord, that this prayer is absurd. my Lord, IBC is being complained of for efficiency, that we delivered information requested in a timely manner. I mean, that is what is needed of government. I have never seen a petition that comes to court to complain about the efficiency of an institution. My Lord, I submit that there was no clearance. We were simply giving information that was contained in the voter register. I humbly so submit. Thank you very much, my Lord.
Yes, my lords and my lady, on behalf of the National Assembly, our representation is led by myself. We have Mr. Paul Nyamodi, Mr. Alex Mbaya, Elias Ouma, and Mr. Crispus Kitala. My lords, to support our submissions this morning, we will rely on the affidavit of Samuel Joroge, dated the 21st October 2024. We'll also rely on the 2nd and 7th respondent submissions, dated the 17th of September 2020. The 2025 as well. My lord and my lady, we fully adopt those written submissions. I will, my lords and my lady, start by making reference or drawing our attention back to submissions by learned Senior Counsel Professor Githu Muigai in relation to or on behalf of the Attorney General. I will borrow from his very able submissions on two critical aspects. Number one, on the nature of impeachment proceedings, and number two, on the jurisdiction of the court. In relation to the nature of the proceedings or the nature of impeachment proceedings, learned Senior Counsel Professor Githu Muigai describes those proceedings as proceedings sui generis and political. And he adds that this is not just in Kenya, but globally. He then fortifies that position with two critical decisions. One decision is the decision of the Supreme Court of the Philippines, where the court says that impeachments are a constitutional measure designed to protect the state from official delinquencies and that it is political in nature. Locally, Professor Githu Muigai did refer the court to the case of Kawira Mwangaza versus the County Assembly of Meru, affirming that impeachment are inherently political and distinct from judicial processes. My lord and my lady, that being the position taken by the respondents, I then would want to trace the architecture of impeachment proceedings within the context of our Constitution. And I start with this point, my lords and my lady. Every 5 years, the people of Kenya go to the ballot to elect their leaders. In particular, and of most interest, is usually the election of the president, together with his deputy. Then, additionally, the election of parliamentarians. My lords and my lady, these elections determine or define the executive leadership and governance of a country. Now, central to the question of elections is the issue about the sovereignty of the vote. That under Article 1, Sabbatical 1 of our Constitution, the sovereignty is in the hands of the people of Kenya. It is for the people of Kenya directly making a determination who then choose who their leaders in those respective elective offices would be. That election, ordinarily, for context, is by secret ballot. And the reason why I say that is so that we understand that in the exercise of sovereign will, there is no need, there is no requirement for any Kenyan expressing their will to give a reason why they make a decision in the manner in which they make that decision. That is what in constitutional parlance, my lords and my lady, has been referred to as the power of we the people. Now, what is the significance of that election? The significance of that election is that it forms the basis of a social contract between the people of Kenya and their democratically elected leaders. That determination of governance or election of leaders is not without terms and conditions. Under our constitution, my lords and my lady, the constitution spells out in very clear terms what the expectations of the people of Kenya in relation to their leadership should be. Specifically, I draw your attention to the provisions of Article 10 of our Constitution. My lords and my lady, Article 10 of our Constitution, for some reason, has gained prominence over the years since 2010, just on the narrow question of public participation. But I want to this morning, my lords and my lady, draw your attention to the fact that under Article 10, the subtitle is national values, and more importantly for the proceedings that we have before you, national values and principles of governance. Article 10 then spells out, 10.1 spells out how it applies and how it's supposed to be interpreted and applied. My interest is drawn specifically to Article 10, Subarticle 2, which says the national values and principles of governance include, then there's A, B, C, and D. Now, those are not mere wishes. Those are the expressions of Kenyans saying that if you are to be a leader in Kenya, then you must lead on the basis of those values. I, for the sake of what is before us, draw our attention to Subarticle 10.2c, which talks about good governance, integrity, transparency, and accountability. Why do I say that? Because impeachments are founded on the basis of good governance, founded on the basis of integrity, transparency, and accountability. My lords and my lady, Kenyans, being fully cognizant of the high authority, high moral authority that they wanted from their leaders, did not stop there. They still, under Chapter 6 of our Constitution, went on to provide for 8 additional articles. The 8 additional articles, my lords and my lady, speak to the leadership and integrity of the leaders. The specific title, my lords and my lady, is Leadership and Integrity under Chapter 6. Article 73 talks about responsibility of leadership. Of significance for purposes of our submissions today, I would want to draw your attention to 73.1, which says authority, responsibility, that is authority assigned to a state officer, is a public trust to be exercised in a manner that then the people of Kenya spell out what they expect of their leaders. Of interest to me is what appears at Subarticle 1A, Roman 3 and 4. Roman 3 speaks of brings honor to the nation and dignity to the office. At Roman 4 it says promotes public confidence in the integrity of the office. Chapter 6 then goes on to provide for many other ways of dealing with leaders at different levels of leadership within the country. Now, again, under that very Chapter 6, Kenyans then make it a cardinal and mandatory requirement that for any public officer to assume office, they must take an oath of office. Now, that oath of office is the epitomization of a social contract that I was speaking to. That oath of office, my lords and my lady, takes different forms depending on the office that one is supposed to be assuming. In the context of a president and deputy president, at Schedule 3, that is the third schedule, there's a very clear indication as to what that oath is supposed to be. It says, I, so-and-so, in full realization of the high calling, I underline high calling, I assume as the president or acting president or deputy president of the Republic of Kenya, do swear or solemnly affirm. The Constitution makes you to swear to the people of Kenya that I will be faithful and bear true allegiance to the Republic of Kenya. It also says that I will obey, preserve, protect, and defend its constitution, this Constitution of Kenya, as by law established, and that all laws, together with all laws of the Republic, and that I will protect and uphold the sovereignty and integrity and dignity of the people of Kenya. I underline protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. A similar oath of allegiance is provided for by the deputy president. When you get time, my lords and my lady, you'll take an opportunity to look at the nature of the oath. What is the significance of these oaths? My lords and my lady, we submit that the oaths are a solemn commitment by the leaders to uphold the Constitution. It also creates public and moral binding commitment to uphold the sovereignty, integrity, and dignity of the people. And more importantly, that it is the accountability pledge in the social contract that I spoke to. At a later part of my conversation, or rather my submission this morning, I'll refer us to the consequences that the failure to adhere to these conditions or the terms of engagement would lead to in respect of leaders at one level or the other of government. Of interest, and just to show how significant the question of the integrity and this commitment to these articles, the provisions of Article 10 and Chapter 6 are, the President, upon assuming office under Article 132 of our Constitution, is given a duty which is akin to reporting on how they are performing. Under Article 132(1)(c), which under the title Functions of a President, it says, once every year, report in an address to the nation on all the measures taken and the progress achieved in the realization of national values referred to in Article 10. It means a responsibility is put on the President or on the President to then report on the measures they've taken in the realization of Article 10. That just tells you how significant how important that provision is to the people of Kenya. Now, that defines, to a large extent, how the executive arm of our government works. The people of Kenya then do not stop at that. They say that in order that we hold you accountable, we must then have an arm of government that deals with or that keeps you on check, that exercises oversight over these elected leaders. Now, it is important to then make reference to Article 1, Subarticle 2, that the people of Kenya can make these sovereign decisions either directly or through their democratically elected leaders, so that then the source of authority for parliamentarians, for instance, is as a result of being the democratically elected leaders. And I'll speak to why that is important. I draw your attentions, my lords and my lady, to Article 93 of our Constitution. Article 93 of our Constitution establishes our parliament. That our parliament consists of the National Assembly and Senate. Now, at Article 94, the people of Kenya go on to determine what the role of parliament is. My lords and my lady, I am sure we'll have an opportunity to read the entirety of Article 94. But for purposes of a presentation that we are making before you and the submission, I draw your attention to the provisions of Article 94, Subarticle 2, says that Parliament manifests the diversity of the nation, comma, manifests the diversity of the nation. It means that is where every single section or, if you wish, person or member of any class in Kenya is represented in Parliament. It takes into account the minority. It takes into account each and every community in Kenya. It goes on to say, it manifests the diversity of the nation, says, represents the will of the people. Read this in the context of Article 1, Subarticle 2, that Parliament represents the will of the people. That when parliamentarians speak, they do not speak as parliamentarians. They speak representing the will of the people. And more importantly, under that 94(2), and exercises their sovereignty. Again, read in the context of Article 1, Subarticle 2, it gives those people, the parliamentarians, the power to exercise the sovereignty of Kenyans. Now, this is a complete surrender in the constitutional sense, that Kenyans surrender their rights to their democratically elected leaders to be able to make decisions on their behalf. And from a craftsmanship point of view, one would want to argue that once we have elected our leaders, we cannot, every time we think there's an infraction of any aspect of a constitution, we then call Kenyans into a plebiscite. That is why we have leaders who then, in the event that there's such an issue, can speak for the people of Kenya. Now, I then draw your attention to the provisions of 94(4), which says that Parliament shall protect this constitution and promote the democratic governance of the Republic. Again, promote the democratic governance of the Republic. The Constitution then, under that Chapter 8, goes on in a slightly more granular sense at Article 95 to say, that is the role of National Assembly, to say the National Assembly represents the people of the constituencies and special interests in the National Assembly. In particular, I would draw your attention to 95, Subarticle 5, which says, the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers, and initiates the process of removing them from office. My lords and my ladies, that article does not give us any option. It says the representatives will review the conduct of our elected leaders, separation of powers. If they find that any of the conducts does not fit within the confines of Article 10 and Chapter 6, then the instructions from the people of Kenya is very clear. Initiate the process of removing them from the office. Role of Senate at Article 96. I refer, my lords, to Article 96, Subarticle 4, that the Senate participates in the oversight of state officers by considering and determining any resolution to remove the President or Deputy President from office in accordance with this, with Article 145. My lords and my lady, why is this important? It is important because we see a textual commitment, and this was a submission made by learned senior counsel Githu Muigai. There's a textual commitment of this oversight responsibility to the parliamentary arm of government, that is the legislative arm of government. We then are drawn to, maybe just so that I conclude that, an explanation under Article 96. Now, this oversight is exercised in differently in different jurisdictions. In Kenya, the Constitution at Article 145 and Article 150 dictates that it is through impeachment. In other places, it is through a vote of no confidence. Both those processes, as submitted by learned senior counsel and with the support of authorities, are political processes. That's why it is important for us that we appreciate the defining four corners of an impeachment proceeding and the role then subsequently of the court. I also add that the manner in which this legislative arm of government exercises its authority is by, number one, deliberating, as we saw in the proceedings before the National Assembly, as well as in the proceedings before Senate. They deliberate, they interrogate, they question. After they've taken an informed position, my lords and my lady, they vote. That is how parliamentarians make their determinations. Now, that is how they express the will of Kenya. That is how they express the sovereignty of the people of Kenya. It then follows that a test that is to be applied in determining whether that exercise of that will and sovereignty was done properly can only be a political test, and I explain why. If we, for instance, conflate that test to be a test in the judicial sense, then the Article 10 and the values that it ascribes, then it immediately run into challenge. Because when we say, for instance, good morals, how will the court determine good morals other than by being subjective? There's no standard through which the court would say, this is a good moral, this is a bad moral. That is why the people of Kenya say, our elected leaders will determine that for us based on those specific provisions of the law. I want to give this in the context of Article 145, Fred Mutatis Mutandis, Article 150. Look at the grounds of impeachment, for instance, under Article 145. One of the grounds is that the existence of, or rather serious reasons to believe that the president or the deputy president, as the case may be, has committed an offense. Now, from a political perspective, the test is purely a prima facie test. I'll be looking at, having listened to what has been presented, what do I make of it? Having heard what has been said, what do I make of this judgment from a morality perspective? If that same question was to be presented to the court, then there are defined standards. For instance, in relation to issues criminal, it is beyond any reasonable doubt. So it means those two tests, if we were to conflate them, then we will be judging a political process through what I would otherwise call a wrong lens. And that is, again, to be supported by the decisions in by the Supreme Court of Philippines, as well as the decisions in our own cases of the Court of Appeal in Martin Nyaga Wambora and 3 others versus the Speaker of the National Assembly, where the court says that courts have neither jurisdiction to initiate a motion, consider a resolution, nor hear charges against impeached officer. The province of the court is solely to decide on the rights of the individuals, not to inquire how Parliament performs its discretionary duties. I dare add, when a vote is presented to you, my lords, there is no requirement that a parliamentarian or a member of the National Assembly voting one way or the other assigns a reason as to why they voted, how they voted. That vote is assumed for all intents and purposes to be the expression of the people who elected that person to that National Assembly or to the Senate, as the case may be. That is the same position taken by the Supreme Court in the Sonko case, which is part of the decisions that we've cited in our bundle and list of authorities. The court then says, courts should be slow to interfere with the exercise of parliamentary discretion, and the mandate of the courts is restricted by the doctrine of a separation of powers to deciding on individual rights and fundamental freedoms. In other words, the processes that were undertaken by the legislative arm of government. Now, I want to draw inference just to make this point sink. Let's look at the provisions of Article 144, for instance, where the president could be removed from office for incapacity. Now, the process goes on. At the tail end of it, Article 144, subarticle 8, yes, Article 144, subarticle 8, the ultimate test is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of the office, the Speaker of the National Assembly shall so announce in the National Assembly. Now, what is important to draw here is that the people of Kenya are deliberate about saying these processes should be shielded from the court process. And that is the political component of these processes. And why is that important? We come from a history, my lords and my lady, where
issues touching on the presidency have taken more than 5 years. In fact, we've had to go to subsequent elections when those matters were still pending in courts. Yet they are matters that are purely political in nature. My lords, for those reasons, the people of Kenya are very deliberate. It's not an omission. They're deliberate that they would want to omit the court from that political process. Now, having outlined that constitutional architecture, we then draw our minds to how did we, or how did the National Assembly conduct the impeachment process that is the subject of this trial and these proceedings this morning. My lords, my lady, this is to be found in the affidavit of Samuel Njoroge, specifically paragraphs 9 to 28. Now, the test or the consideration that the court will be looking at is the manner in which the National Assembly complied with the provisions of Article 150, read with Article 145, mutatis mutandis. Now, number one, there's the question of establishment of the grounds. The grounds are under Article 145(1). I need not read them. What is important, though, is that once a member of parliament presents a motion in the nature of Article 145, that is for impeachment of a president or a deputy president, as the case may be, then the Speaker of the National Assembly would have to satisfy himself on a number of threshold questions. I'll refer you to where this was done. Now, the first item that the Speaker looks at is whether, as framed, the grounds that have been presented in Parliament meet the grounds in Article 145. That is, I think, to be found in the Standing Orders number 64(1), which defines how that motion is supposed to be made. It says in a very granular sense that it is supposed to be in writing, and number two, it must spell out the grounds that are articulated in Article 145. Standing Order number 64(1)(a) then goes into looking at the manner in which the Speaker reviews those grounds as to whether they fit within the constitutional architecture. And that is a role that is under those specific standing orders left for the Speaker of the National Assembly. My lords and my lady, I'll draw you and I'll probably point you in the course of my submission to the findings of how the Speaker of the National Assembly deals with those requirements. But the sum of it is that the Speaker of the National Assembly satisfies himself at page 745. Let me just try and get the page 745. As to the two tests, both under Standing Order number 64(1) and Standing Order number 64(1)(a), that both those conditions have been met. Now we go to the second test, and I'll take you just in a short moment to the Hansard to speak to this. We go to the second test, which is the threshold test. Now, the motion must be supported by at least, in the words of the Constitution, if a motion under clause, a member of the National Assembly supported by at least a third of all the members. So the first threshold test is that the motion is supported by at least a third of all the members. I'll draw your attention to how the Speaker of the National Assembly deals with that, determining that question. He makes an express finding that all the members refers to all the members elected, and he gives a specific number as to what all the members mean. He then gives a mathematical representation that for that threshold to be met, there must be at least 117 members supporting the motion that is presented. In the case at hand, my lords and my ladies, the number of people who supported the motion was 282. 291, members of the National Assembly supported the motion presented by the member for Kibwezi. Now, the second test is under Article 145(2), which says, if a motion under Clause 1 is supported by at least 2/3 of all the members of the National Assembly. Now, the second threshold test under Article 145, Subarticle 2, is 2/3 of all the members of the National Assembly. Again, the Speaker of the National Assembly, at the conclusion of that exercise, makes a finding as to the number of people who supported or voted in support of the motion. In particular, they say 291 out of 349 members voted in support of the motion. That is what learned Senior Counsel Professor Githu Muigai referred to as a super majority. My lords, in terms of compliance, those three thresholds are fundamental. I want to take a quick moment to just draw your attention to the specific area where this is to be found in the communication from the chair. Yes, I'm there, my lords and my lady. The Hansard runs from page 744 in volume 2 of the annexure SN3 of the affidavit of Samuel Njoroge. My lords, my lady, after identifying the specific issues of concern, the Speaker at page 748 says, having examined the notice of a special motion by the member for Kibwezi West, I find the special motion meets the requirements relating to the form and threshold set out in Articles 145(1) and 151(b) of the Constitution and Standing Order 64. Then goes on to say, I have also satisfied myself that the number of members who have appended their signatures in support of a special motion exceed the minimum threshold of 117 members. Then further on it says, having determined that the special motion is admissible, let me now focus on the next step of giving notice to the special motion to the House. Understanding Order number 47, 4A, which provides that with respect to the motion of removal from office, a member shall give notice of a motion in the House within 3 sitting days following the approval by the Speaker. Now, that, my lords and my lady, when you get an opportunity, is how the Speaker of the National Assembly deals with the threshold questions. We submit on behalf of the National Assembly that those thresholds were met. After meeting the thresholds, what then do we address our minds to? We stop there, my lords and my lady, to ask ourselves a number of questions that arose in the course of the presentation before you. Learned Senior Counsel Paul Mwite, supported by Counsel Mr. Kibe Muigai, Mr. Ndegwa Njiru, and even Mr. Ogada, described the pace at which the impeachment process was done as a breakneck speed. My lords and my lady, where does the pace or what determines the timelines within which impeachment is supposed to be done? A reading of the entire Article 145 gives a total of 19 days within which the impeachment process should have been completed. And my lords and my lady, that said, if you calculate the 2 days, the 7 days, and whatnot, it gives you a total of 19 days. That said, my lords and my lady, the question of the timely and expeditious determination of an impeachment motion is a dictate of the Constitution. It is not a whimsical escapade or undertaking by the either National Assembly or the Senate. Those timelines are cast on stone, and they must be done within those timelines. Now, it is not unique when we're dealing with issues touching on the presidency because of the sensitivity of a presidency to a republic. Under Article 145 of 140 of our Constitution, any question as to the validity of election of a president is determined within 21 days. Again, under Article 144, a motion for removal of a president for incapacity is to be determined within 30 days. What do we read from these very tight timelines? We read the history that we've walked, that in dealing with these matters, which are obviously possibly divisive and also very contentious, if you leave parties to attend to those processes as they would, we would not be able to make those determinations within the contemplated timelines. My lords and my lady, that is the nature of our Constitution. Learned Senior Counsel Paul Muite then also submits that impeachment is a nuclear option and should be the last resort in dealing with disciplinary issues around a presidency. I mean, around dealing with impeachment of a president or his deputy. My lords and my lady, contrary to that, Article 10 and Chapter 6, couched in very mandatory terms, speak to what I'd call the political hygiene of a country. They determine what follows. And remember, in the course of my presentation, I said I'll revert back to Chapter 6. At Article 75, my lords, 75(5) says, no, 75(3), sorry. A person who has been dismissed or otherwise removed from the office for contravention of the provisions specified in Clause 2 is disqualified from holding any other office. That is an important dictate of the Constitution. It doesn't give us an option. It means in black and white that to the extent that His Excellency, the Deputy President, was found to have been in breach of this Chapter 6, specifically the ones referred to Clause 2, which is to be read with Article 10 and Article 73. Once he is impeached, the Constitution says he is disqualified from holding any office. I underline any office. It is not just about the presidency, it is about any public office. And I think that answers the question that learned senior counsel posed to this court. It will be an office either at the national level, at the county level, at the constituency level, and I dare add, even at the county assembly level. Any office that is defined under Article 260 of our Constitution, the test being a simple one. Will that office require that the payment to that office holder be made from the consolidated fund? So the long and short of it, my lords and my lady, is that this article is a bar, unless changed through any other process, is a bar to His Excellency the Deputy President from holding any office, any public office. I go to the next question around fair hearing. This was submitted to quite at length by my learned and good friend, Mr. Dudley Ochiel. I want to add that from a factual perspective, and this is available in the Hansard, each of the senators, each of the members of the National Assembly was presented with the volumes or the documents that contained the petition. The first respondent, His Excellency Rigathi Gachagua, then the Deputy President, was given an opportunity to respond, which, again, as you'll see from our Hansard, he very ably responded to in writing. He was again given an opportunity to attend in person before the National Assembly and before the Senate. Again, he seized that opportunity and attended. He did not just attend alone, he attended with a battery of at least 14 lawyers. That is what the law contemplates. Now, the lawyers were given an opportunity to ask questions, and the Hansard will bear me witness. I'll refer you to the specific aspects of the answer. That the lawyers representing the Deputy President then had very robust engagement, questioning each and every of the grounds that was represented or that was tendered for purposes of the impeachment. After that, the members of the Senate, just like in the National Assembly, were given an opportunity to ask questions. Why is that important? It is important because it shows that these two houses were given an opportunity to interrogate. And interrogation here is so that they're able to make informed decisions. My learned colleague Moses will address us at a later stage on the question of public participation. You will see how that public participation played in. The only point I would want to make is that when that public participation was conducted, it was conducted so that the members of the National Assembly and Senate alike could touch base with the people they represent to see what their thoughts were in relation to the question of impeachment. It is not for this court, I add. It is for the members of the National Assembly and the Senate, as the case may be. Now, is that a case of somebody who was not afforded an opportunity to be heard? My lord and my lady, that brings me to the central question in relation to that issue. The central question is in relation to the adjournment that was declined by the Senate. Let me say this. I will refer you to the provisions, or rather to the recordings in the Hansard, on how the application for adjournment was made by learned senior counsel Paul Muite. My lord and my lady, it is apparent from those proceedings that no ground or no evidence was presented before Senate to enable them, to support the exercise of discretion. With the material that was available before Senate, they made a determination on the basis of the fact, and they did ask this, that the proceedings before the House were time-bound proceedings. They put a specific question to learned senior counsel Paul Muite. What do you want us to do? My lords and my lady, I refer you to the specific answer that was given by learned counsel Paul Muite. Now, not a single piece of paper was presented to the Senate for them to be able to make a determination as to the allegation of ailment. Why is that important? It is important for this reason. The petitioners have come before you to try and question the exercise of discretion of the Senate in denying the motion or the application for adjournment. It is very clear that whilst in Senate, they did not tender any material to support that application. I underline any material. Learned senior counsel, the Honorable James Orengo, and this is captured in the Hansard, speaking to this same process, says at the very least, he would have expected at least a doctor from Karen Hospital to come and confirm to the Senate the condition of His Excellency, the Deputy President, then. That did not happen. That, my lords and my lady, we are seeing an affidavit emerging from the woodworks today. Of what probative value? If you're being invited, my lords and my lady, to evaluate the material that was before the Senate at the point at which they were making that determination declining the adjournment, what is the value of an affidavit being filed before you today to support that application? My lords and my lady, it must be abundantly clear that that application is not being made before this court. This court is merely being invited to review the manner in which Senate exercised its discretion. I dare add that absent any supportive material, then Senate had absolutely no basis of granting the orders that were sought. My lord, it should not be lost that even in Senate, and this is also evident in the Hansard, the petitioner, His Excellency, the Deputy President, then Rigathi Gachagua, was represented by a team of 14 lawyers. That is on record. My lords and my lady, are we saying that out of these 14 lawyers, none of them would have imagined that it is important to lay a document to satisfy the Senate or to give grounds for the adjournment that they were seeking? We think that is a far cry. That was a deliberate omission. This court cannot now go into looking for reasons that ought to have been looked at, or items or material that ought to have been looked at by the Senate, but which were never quite placed before the Senate. It means that the affidavit that has been presented by Dr. Dan Gikonyo before the proceedings, I mean, to support the proceedings before you, is of absolutely no value, because no material can be introduced. And I would equate it to the court proceedings. My lord and my lady, if I was to make an application before you today, my team leader, learned Professor Githu Muigai, is not in, and I just say, I want us to adjourn these proceedings, important as they are, then I tell you, I suspect that is unwell. Chances are the court will say no. If the court says, I have not established the grounds for grant of that adjournment, would it be open for me to now go to the Court of Appeal to say that I now have a document 1.5 years after the application has been made? I want you to look at this affidavit. It confirms indeed that the person in issue was actually unwell. That material, having been missing in the proceedings before Senate, cannot be used as a basis of making a determination on that on the exercise of that discretion one way or the other. My lords and my lady, I would want to very quickly, I'd said I'll refer the court to various areas within the Hansard that speak to these items. In the third and fourth respondents' annexures, marked as Part 4, this big volume, unfortunately it's not paginated, they are the proceedings of the Senate, specifically at page 7, where Learned Counsel Paul Muite makes the application for adjournment, and it runs all through to page 15. My lords and my lady, I ask that when you get an opportunity, just read for yourselves, and you see the deliberations as they unfolded before the Senate. There's then the communication by the chair of the Senate, which appears at page 15 after that of the same document. Again, the reasoning of the Speaker in relation to the question of adjournment, ultimately putting the matter for resolution by the whole House. My lords, that is the part of this Hansard which speaks to how the application for adjournment was made. I need not read the whole of it in the interest of time. I'm sure the court will find an opportunity to read that. I think I'd refer the court to the specific parts of the Hansard from page 744 of volume 2, annexures running from page 711 to page 1301, specifically page 744 running through page 746, up to page 749. My lords and my lady, that is how the National Assembly deals with the issue of the issue of threshold. Yes, my lords and my lady. So we then ask, on behalf of the National Assembly, that you find that the petitioners have not met the threshold for you to exercise the review that they're inviting you to exercise. I want to add, as I mentioned earlier, that the review that is supposed to be before you is a review of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted, what would be this reason that would be testing if we were to apply attest, for instance, of Wensbury unreasonableness under the anisminic sense, there'll be no reason that you'll be looking at. From a political sense, my lords and my lady, the only solution left is by the people then saying that that specific member of the National Assembly did not express our will. We will deal with them in two ways. The Constitution says either you deal with them at the point of re-election or you deal with them through a recall, not in the manner in which we seek to want to, in a granular sense, lay blame on the findings of the members of Senate. I pray that the petitions be dismissed. May I now cede the ground to my learned friend, Mr. Mushemi, to make his presentation. I'm most obliged.
Thank you, my lords and my lady. My name is Michael Mushemi. I appear for the 9th respondent. Your lordships, we are relying on our replying affidavit dated the 22nd of October 2025. Our submissions dated 15th February 2026. Our supplementary submissions and list of authorities dated 5th of May 2026, and our further list of authorities dated the 12th of May 2026. Very briefly, my lords, since the enactment of the 2010 Constitution 16 years ago, Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3), and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024, and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague, Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. When the motion went to the Senate, and the vote was taken, and I'll only rely on one ground number 1, 54 members voted for the motion, 12 against, and 1 abstention.
My lords, you have been told that Parliament acted as a lynch mob, but there has never been occasion in the 16 years that this constitution has existed that Parliament has voted on such numbers. If that were the case, you would have been given instances or other examples where Parliament has acted in this manner. And the reason these numbers were achieved, supermajority in both houses, and you will see that they exceed the BBI numbers. In fact, in the National Assembly, they exceed by almost 60 members of the National Assembly, is because of the weight of the 11 grounds of impeachment. My lords, it is our submission that in our country, there is no country anywhere in the world with a higher threshold of impeaching a president or deputy president in this case than this country. If you go to the United States, for example, in the House of Representatives, which is the lower house, you only require a simple majority to approve the articles of impeachment. It is in the Senate that you thereafter require 2/3. If you go to the Philippines, and here we are comparing presidential systems, you require 1/3 of all the House members to endorse the complaints and 2/3 of the Senate. Nigeria has a system such as ours, and so does Brazil. So it is our submission that the safeguards provided by our Constitution are adequate to ensure that this process is not abused. Our Constitution further requires public participation, and this requirement now sets it apart from those examples that I have given you, where impeachment is handled solely by elected representatives. And as will be submitted by my colleagues, public participation was conducted across all constituencies in Kenya throughout this process. So in fact, my lords, we have no comparative in the world. We have the most progressive and advanced constitution in the world when it comes to impeachment of the president. The argument by the petitioners that either Parliament acted as a lynch mob is again not true. The argument that the deputy president was elected by the people, whereas is true, the contra-argument is that he was also sponsored by a political party to run for office. He ran for office as deputy president under the banner of a party called the United Democratic Alliance, UDA. And my lords, under Article 38 and under Article 91, political parties are the foundation of our constitutional democracy. In the National Assembly, at the time the deputy president was being impeached, the UDA had 144 members of the National Assembly. Out of those, 114 voted to impeach the deputy president, with 21 voting against. And it is our submission that it is clear that he had lost the confidence of his own political party to continue holding office. Our colleagues have cited numerous authorities from South Africa, and South Africa is a good example of how leaders respect decisions of political parties. President Mbeki in 2008 resigned after he was recalled by his own political party. He was not heard by the party. He was not invited to any hearing. The party just met and said they had lost confidence in him. This decision was submitted to him, and he said that he respects the decision of the party, and he resigned. The same thing happened to President Zuma, who resigned on Valentine's Day of 2018. And the following day, President Ramaphosa was sworn in. The party simply said, "We have lost confidence in you." Closer home here in Zimbabwe, when President Mugabe was removed as leader of ZANU-PF on the 19th of November 2017, again he opted to resign because he was going to face an impeachment vote. Parliament is often considered the highest form of representation in a democracy because it serves as a primary venue where elected members represent the diversity, will, and sovereignty of the people. It is our submission, Your Lordship, that the first petitioner not only lost the confidence of Parliament, but he had lost the confidence of the political party that sponsored him to run for political office. My Lords, you have been told a lot about the grounds of impeachment. And in Article 145, the framers of our Constitution and the context of our Constitution has to be read in its plain text. They gave 3 grounds for impeachment, and they said gross violation of a provision of this Constitution, and where there are serious threats of believing that the President has committed a crime, and for gross misconduct. There was very good reason for the drafters to give these 3 reasons, because they were not to subject the President or the Deputy President to judicial standards by members of Parliament. They were not to subject them to judicial standards. The charges against the Deputy President, 11 of them, are not to be subjected to judicial standards. I know my colleagues will give you examples of how other presidents have been impeached. But presidents all over the world have been impeached for far lesser crimes, for far lesser transgressions than you have seen here in our country. Here the impeachment was on serious violations of the Constitution. I'll go to the grounds of the impeachment, my Lords. And you are told about subsidiarity. Ground number 6 of the impeachment, where the Deputy President was accused of crimes under the National Cohesion and Integration Act. Ground number 7, where he was charged with the economic crimes under the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. And ground number 8, where he was charged with contravention of Section 29 of the Leadership and Integrity Act. You have been told that there should have been deference by the National Assembly to the institutions, that is NCIC, EACC, and the DCI, to allow them to investigate those crimes before Parliament could do the duty that they did. That is not true, and we are guided by a decision of this court by a 5-judge bench in petition number 295 of 2018, Philomena Mbete Mwilu versus DPP and others. This was a 5-judge bench: Justice Omondi, Justice Ngugi, Justice Tuyot, Justice Musyoka, and Justice Muita, delivered in 2019. And in this decision, particularly paragraph 379 of that decision, the judges go on to say, and this was a decision which the Deputy Chief Justice had challenged charges that had been preferred upon her by the DPP in the Chief Magistrate's Court. And the judges say that from the analysis, the following principles emerge. First, in the absence of an express statutory or regulatory provision requiring prior approval or sanction from another authority in order to prosecute a judge or judicial officer will face trial directly in the event that he or she is alleged to have committed an offense. However, and this is the second principle, where there is a specific legal framework for dealing with misconduct and or removal of judges, cases involving misconduct with a criminal element committed in the course of official judicial function or so closely proximate or linked to the judicial officer must first be referred to the body responsible and the disciplinary or removal process commenced. My Lord, it is our argument that this decision applies in this case. And the holding, in fact, was that while the DCI is not precluded from investigating criminal misconduct of judges, there is a specific constitutional and legal framework for dealing with misconduct and removal of judges. Consequently, cases of misconduct with a criminal element committed in the course of official judicial functions or which are so inextricably connected with the office or status of a judge shall be referred to the Judicial Service Commission in the first instance. Your Lordships, it is our argument that this applies even to the office of the President and the Deputy President, that where there is already a mechanism of disciplining them, then that mechanism ought to be exhausted first and not the other way around. In fact, our Constitution does not contemplate a situation where the President or the Deputy President would be facing organs of security which are appointed themselves by the President. And that is why the Constitution then provides this mechanism in Article 145 to discipline the President and the Deputy President and to hold them account through their removal by Parliament. This position was supported by several other authorities, and there is an article I will urge you to read, The Temporary Criminal Immunity for Federal Judges, that is contained in that authority. Secondly, Your Lordship, the petitioners argued, particularly in relation to ground number 9, that the National Intelligence Service ought to be under a civilian supervision. And whereas that is true, Article 239 provides that it is one of the national security organs, the other two being the KDF and the National Police Service. And in fact, in the composition of the National Security Council, and there are 9 people who sit in that council, it is only the Deputy President who is not appointed by the President, meaning that the Deputy President is very central to the running of that council. Your Lordship, it is our submission on the issue of fair hearing that the Deputy President in the National Assembly, and Mr. Gumbo has taken you through this, was present. He was represented by legal counsel. And I think the place you need to dwell on most is the Senate. It is my client's case that, in fact, prejudice in the Senate was suffered by the 9th respondent and the National Assembly. And why do I say this? This is because the first petitioner was able to present his case and his documents. He was able, through counsel, to cross-examine witnesses of the National Assembly, including the 9th respondent. But when the time came to cross-examine him, he was not available. So the prejudice was not on him, because his evidence was treated without any cross-examination. And you see the result of the Senate, that in fact 6 of the grounds that the 9th respondent had presented through the National Assembly were not confirmed by the Senate. And the reason they were not confirmed was because the Deputy President was not cross-examined. Nevertheless, of course, any of the grounds is enough to seal his fate, but there was serious prejudice, not by the Deputy President, but by the National Assembly. On the issue of the committee route and the plenary route, our submission is that the plenary affords the whole House
Wojoria mwiri mujia kana wina ndumiriri oyo the ugenda ikinyire muingi riu TLTV ni turakwihoya na gitio kinene tutume ndugu tutirithanie biashara yaku imenyeke yebo ciaku cimenyeke kiugo kia Ngai kihunje ngogo nginya ngogo ona kana ndumiriri yaku ikinyire aria marongoreirio araniria na ithuĩ kũhĩtũkĩra thimũ namba 0791 914 607 0791 914 607 kana kũhĩtũkĩra mũtambo witũ wa Facebook TLTV. Gũkũ nĩkuo tũracagararithia njata yaku.
Bwana Yesu asifiwe. Mimi naitwa mchungaji na mwimbaji wa nyimbo za Injili Simon MK. Na ili kupata wimbo wangu Muthenya wa Mithenya, naingia kwenye simu yako, kisha unaandika neno sikiza, ukifuatia na code ambayo ni 6987504 6987504.